Under the Securities Exchange Act of 1934, a broker-dealer is generally any person or entity engaged in the business of effecting securities transactions either for others or for its own account. A broker under 15 U.S.C. 78C(a)(4) is defined as any person or entity engaged in the business of effecting transactions in securities for the account of others. This includes firms that execute trades, solicit investors, operate trading platforms, or otherwise are involved in facilitating securities transactions on behalf of clients. A dealer under 15 U.S.C. 78C(a)(5) is any person or entity engaged in the business of buying and selling securities for their own account, but not merely as an investor. Dealers typically make markets, quote prices, or hold themselves out as ready to buy or sell securities on a regular basis. A firm that engages in either or both sets of these activities, that is, executing trades for clients or trading for its own account in the ordinary course of business, is required to register as a broker-dealer unless exemptions apply. In today's video, we're going to examine 3 critical regulatory filings that broker-dealer applicants and existing members must understand. Form BD, the new member application NMA under FINRA Rule 1013, and the continuing member application CMA under Rule 1017. Now, Form BD is the uniform application for broker-dealer registration filed through FINRA's Central Registration Depository System, CRD for short. It is required for registration with the SEC, FINRA, and applicable state securities regulators. This form functions as the foundational disclosure document. It provides regulators with essential information regarding the applicant's ownership, control structure, business lines, clearing and custody arrangements, affiliations, and disciplinary history. Importantly, Form BD must be amended promptly whenever the information it contains becomes inaccurate or incomplete. So let's start with the new member application. While Form BD initiates the registration process, FINRA membership is granted through the new member application, or Form NMA, pursuant to Rule 1013. The NMA is reviewed by FINRA's Membership Application Program, also known as MAP, and this requires the applicant to demonstrate compliance with each of the 12 standards set forth in Rule 1014A. This includes 1, a fully documented business plan, 2, adequate net capital and financial projections, 3, identification of licensed principals, and 4, execution-ready clearing and operational agreements, 5, a comprehensive set of written supervisory procedures, and various other requirements. For technology-enabled or digital asset firms, it's important to note that FINRA expects the platform to be fully operational and capable of demonstrating the complete transaction lifecycle. So onboarding, execution, clearance, settlement, and internal surveillance protocols at the time of submission. So the application must be substantially complete at filing. Incomplete submissions will be rejected and subject to forfeiture of fees. Section 3, we're going to talk about continuing member applications. So once a broker-dealer is approved as a FINRA member, any material change of business operations must be evaluated under FINRA Rule 1017, which governs continuing member applications. Material changes consist of things like a merger or acquisition involving another member firm, a direct or indirect change in control involving 25% or more of equity or partnership capital, the addition of a new business line such as underwriting or proprietary trading or market making that you didn't do before. It could also include expansion in personnel and branch offices beyond the safe harbor exemptions, or it could involve changes to the firm's product mix that affect capital requirements or supervisory obligations. It's a common mistake to assume that filing Form BD as an amendment satisfies CMA obligations, and it doesn't. The two serve different regulatory functions, and a CMA requires prior FINRA approval before the change can be implemented. So in summary, Form BD initiates registration, the NMA grants membership, and the CMA governs material changes thereafter. So each filing interacts with the others, and compliance requires precision, foresight, and a comprehensive understanding of the regulatory architecture. Thanks for watching this video. My name's Braden Anderson. I'm a partner at Gesmer Updegrove, and if you have any more questions, want to talk about this more, make sure to follow me, hit that subscribe button, or send me an email.